Imagine you are managing a 3 billion dirham infrastructure project in Dubai.
Huge stakes.
Right. You are at the absolute peak of construction. You're pouring concrete. You're coordinating like 10,000 workers on site.
A massive logistical undertaking.
Exactly. And then suddenly a geopolitical crisis erupts. It just completely chokes off 80% of your global steel supply practically overnight.
Which is a nightmare scenario.
Total nightmare. You are bleeding 1 million dirhams a day in overhead, and your actual supply costs just quadrupled. So what do? Do you just tear up the contract and walk away?
Most people wish they could.
Right. Or do you beg a judge to step in and somehow rewrite the financial terms of your deal? Welcome to this advanced continuing professional development masterclass. We are treating this deep dive as a rigorous, peer-to-peer strategy session for advanced legal and commercial professionals.
And if you are listening to this, you are already navigating the absolute labyrinth of complex risk allocation in the Middle East.
Yeah, you are here for the basics. You are here because you need to know exactly how the law operates when a multi-billion dirham deal just hits a catastrophic wall.
Precisely, because, the legal landscape we are navigating today, it does not forgive imprecision. And it certainly does not care about your profit margins.
It really doesn't.
No. We are analyzing the UAE Civil Transactions Law today, and we're focusing strictly on the microscopic yet commercially massive differences between two fundamental pillars of risk allocation.
Right, which are Article 249 governing exceptional circumstances and hardship, and Article 273, which is the doctrine of force majeure.
Exactly.
Okay, let's unpack this. Our mission today is to dissect exactly where these two articles diverge.
Yeah.
We are building this masterclass on a stack of, high-level statutory frameworks, jurisdictional analyses, and highly technical legal briefs regarding the 1985 UAE Civil Code alongside overarching commercial principles.
It's a dense stack of source material for sure.
Very dense. But think about the stakes here. You draft this airtight contract. Your legal team spends months, literally months, negotiating every single comma.
Fighting over every word.
Exactly. You build this conceptual vault, thinking it can withstand absolutely anything, but then real-world chaos hits like an earthquake.
And that's the real test.
Right. The question is, when the ground splits open, how does the UAE Civil Code save you, and where does it leave you completely exposed?
Well, to understand the earthquake, we first really have to understand the vault.
Walk us through that.
Sure. The theological core of contract law, particularly in the Middle East, is the principle of pacta sunt servanda.
Agreements must be kept.
Exactly. Agreements must be kept. It is the absolute bedrock of commercial stability. When two sophisticated parties enter into an agreement, they are exercising their freedom of contract.
They're building the vault.
Right. They are essentially writing a private law that governs their specific relationship. And the courts, the state, the legal system, their primary mandate is to respect and enforce that private law.
So if I agreed to deliver 1,000 tons of steel on a Tuesday for a specific price, the foundational expectation is that I will deliver it.
Yes. Either the market shifts and it becomes incredibly inconvenient or even unprofitable for you.
Right. But this is where I see practitioners from, say, London or New York stumble hard when they come to the region.
Oh, constantly.
Because in a common law system, if you don't explicitly build an escape hatch into that vault, if you don't physically write a force majeure clause into the contract, you are basically trapped inside when the earthquake hits.
Right. You are. You're left relying on the common law doctrine of frustration, which, as you know, is notoriously impossible to prove.
It's a nightmare. It is arguably the most dangerous blind spot for foreign practitioners working here.
It really is. Under common law, contractual autonomy is taken to such an extreme that the court will rarely, if ever, imply protections that you didn't draft yourself.
But the UAE statutory framework approaches this tension fundamentally differently, doesn't it?
It does. The UAE Civil Code is a civil law system. It draws heavy inspiration from the Egyptian civil codes drafted by Senhuri.
Right, which harmonized French civil law concepts with Islamic jurisprudence, or Sharia.
Exactly. And in Islamic jurisprudence, there is this deep-seated philosophical emphasis on fairness, on equity, and crucially, the prevention of unjust enrichment or ruinous loss.
Which is known as gharar, right?
Yes, gharar. Because of this philosophical root, the doctrines of force majeure and hardship aren't just, optional contractual add-ons.
They aren't just boilerplate.
No, they are baked directly into the DNA of the Civil Code. They exist as a matter of statutory right.
So the state basically provides the escape hatch automatically, even if you didn't write it into the contract.
Yes, by default.
Though, I mean, as anyone listening to this masterclass knows, you absolutely still draft those clauses to take control of the narrative, right?
Oh, absolutely. You never want to leave it entirely to a judge's discretion if you can define the parameters yourself.
Right. Now, before we tear into the actual mechanics of these articles, we do need to acknowledge the elephant in the room.
The 2026 update.
Exactly. We are analyzing principles anchored in Federal Law Number 5 of 1985, but the entire region is bracing for the new Civil Transactions Law, taking effect on June 1st, 2026.
We are on the precipice of a monumental shift, yes.
So why are we focusing on the old law today?
Because the jurisprudence, the rigorous judicial tests, and the commercial logic developed over 40 years under the 1985 law, that provides the essential baseline.
Ah, I see.
Yeah, the upcoming 2026 law modernizes the framework, sure, but the foundational philosophy of how UAE courts evaluate absolute impossibility versus economic hardship remains deeply entrenched.
So you basically cannot navigate the new law without a master-level understanding of how the courts have historically applied Articles 273 and 249.
Exactly. The past is prologue here.
Which perfectly sets the stage for our first major mechanism. Let's look at the nuclear option. Article 273, impossibility of performance and force majeure.
The big one.
Right. When the earthquake hits, this is the doctrine that says the vault is completely crushed and the contract is just dead.
Nuclear option is exactly right. Article 273 is not about a contract becoming difficult.
Right.
It is not about a contract becoming unprofitable. It is about absolute, objective impossibility.
And there are strict conditions to trigger this.
In fact, extremely strict. To trigger this, you must satisfy a rigorous set of concurrent conditions. First and foremost, the event must have been unforeseeable.
Okay, let me push back on this right away because, I mean, unforeseeable is such a slippery word.
It's heavily debated.
Right. In today's hyper-connected world, with 24-hour news cycles and global data networks, isn't like everything technically foreseeable.
You'd think, sir.
If I sign a shipping contract to move goods through the Red Sea today and a vessel gets attacked tomorrow, I can't claim I didn't foresee the risk, right? I mean, the meteor's already in the sky.
You are hitting on the exact friction point litigators argue over every single day.
So how does a judge look at it?
The standard is objective. The court asks, would a prudent commercial actor in your specific industry have anticipated this risk at the exact moment the contract was signed?
So timing is everything.
Everything. If the geopolitical tension was already headline news, you fail the test.
Because they should have priced it in.
Exactly. The law assumes that a sophisticated party aware of a risk will allocate that risk through pricing or specific contractual caveats. If you didn't, you assume the risk.
But let's say I signed a 10-year fixed-price contract 5 years ago.
Yeah.
During an era of, unprecedented regional peace.
Right.
A sudden outbreak of armed conflict today would likely satisfy the unforeseeability threshold for that specific contract, right?
It very likely would. The baseline was peace when you signed.
Okay, so timing of the signature is the first hurdle. But it can't just be a surprise. It also has to be completely out of my hands.
Correct. Which brings us to the requirement of externality. The event must arise from circumstances entirely beyond the invoking party's control.
Okay, define control in this context.
What's fascinating here is how courts view this concept in the context of modern megaprojects. A construction project today isn't just one company, right?
Oh, not at all. It's a fractal network of hundreds of subcontractors and suppliers.
Exactly.
Right, so if my primary steel supplier goes bankrupt because, I don't know, their CEO was embezzling funds, I can't build the bridge.
You're stuck.
Yeah, and to me, the main contractor, that feels completely external. I didn't embezzle the money. Can I claim force majeure?
Under UAE law, absolutely not.
Wait, really? Why not?
Because the courts will generally view your supply chain, your subcontractors, and your workforce as existing within your sphere of control and responsibility.
Oh, wow.
Yeah. If your subcontractor fails, that is considered a failure of your internal commercial apparatus, not a force majeure event.
So what actually counts as external then?
An external event is a sovereign state closing its borders, a sudden change in statutory law, or, a Category 5 hurricane.
It has to be an act of God or the state.
Yes. It must be an act of God or an act of a sovereign third party that has absolutely no contractual nexus to you.
That is a harsh standard. And even if a hurricane hits, I can't just throw my hands up and walk away, can I?
Yeah.
There's a mitigation requirement, isn't there?
Yes, that is the principle of unavoidability.
Okay, unpack that.
The consequences of the external event must be objectively impossible to avert, and the burden of proof is incredibly heavy here.
Give me an example.
Sure. Say a port is closed due to a sovereign blockade.
Okay.
The court will ask, could you have rerouted the cargo by air? Could you have sourced the raw materials from a completely different country?
Even if it's way more expensive?
Yes. If there was a commercially viable workaround, even a difficult or expensive one, and you failed to take it, the event was not unavoidable.
So you really have to exhaust every single option before you claim impossibility.
Every single reasonable option, yes.
Let's talk about the final link in the chain, causality. Because, I mean, I've seen contractors try to use a genuine force majeure event to cover up their own terrible management.
Oh, it happens all the time. The classic smokescreen.
Right. They're 8 months behind schedule because of endless design errors and bad planning. Then, boom, a flood hits the site and washes out a week of work.
And
Suddenly, they're submitting claims trying to wipe out the entire 8-month delay, blaming the flood.
And a sharp judge or arbitrator will dismantle that claim immediately.
Because the flood didn't cause the first 8 months of delay.
Exactly. There must be a direct, unbroken causal link between the unforeseeable, external, unavoidable event and the specific failure to perform.
So the flood only excuses what the flood actually stopped.
Right. The flood only excuses the obligations that were actively impeded by the flood, and only for the duration of the flood. It absolutely does not act as a retroactive pardon for prior negligence.
Okay, I want to aggressively challenge this idea of objective impossibility, because I can hear commercial directors listening to this and literally tearing their hair out.
Let's hear it.
Let's step away from physical destruction like floods or fires. What if my supply costs just tripled overnight?
A purely economic shock.
Exactly. Let's say a critical raw material is suddenly embargoed globally by a superpower. The only available alternative on the global market costs 400% more.
Okay.
Performing the contract at that price would literally bankrupt my company. It would result in immediate corporate insolvency. From a commercial reality standpoint, performing that contract is impossible.
It is a brilliant commercial argument, and it is legally dead on arrival under Article 273.
Dead on arrival.
Entirely. This is the hardest pill for business leaders to swallow. From the perspective of UAE civil law, bankruptcy is merely a financial state.
Wait.
It is not a physical or legal impossibility.
So bankruptcy is not impossibility. That feels incredibly harsh.
It is absolute. Impossibility means the obligation cannot be executed, period.
Like, physically cannot be done.
Exactly. The steel physically cannot be manufactured because the factory is literally ash. Or it is legally impossible because a new government decree explicitly outlaws the export of that specific good.
If I just can't afford it.
If the steel can be procured somewhere in the world, but it simply costs you 4 times as much, performance is still objectively physically possible. You just lack the capital to afford it.
Wow.
Financial ruin does not satisfy Article 273.
Okay, let's assume we actually hit all those brutal metrics. The factory burned down. Total objective impossibility. What are the mechanical legal consequences under 273? Because it isn't just a pause button, right?
No, it is a termination mechanism. In the case of total impossibility, where the core obligations of the bilateral contract can never be performed, the contract is rescinded automatically by operation of law.
So it just dies.
Both parties walk away. The obligations are completely extinguished. The law attempts to put the parties back into the position they were in before the contract was signed.
Meaning what, practically?
Meaning unearned advances are returned, deposits are refunded, but crucially, no one is held liable for breach damages because the failure was not their fault.
But what if only a piece of the contract is impossible? Let's say a master developer is building a massive complex with 10 luxury towers.
Okay, a mega development.
Right. Halfway through site prep, they discover a massive, historically significant archaeological site right under the footprint of tower number 3.
A classic unforeseen hurdle.
The government immediately steps in, seizes that specific plot of land, and forbids any construction on it forever. But the other 9 tower plots are totally fine.
That is the textbook definition of partial impossibility. Under Article 273, the contract is severed.
So they just cut that part out.
Exactly. The legal surgical strike only removes the impossible element. The obligation to build Tower 3 is extinguished. However, the remainder of the contract, the construction of the other 9 towers, continues to operate in full force.
And what if the impossibility is just temporary? Say, a pandemic lockdown that explicitly bans construction work, but only for 3 months.
In long-term contracts, temporary impossibility generally suspends the obligations for the duration of the impediment.
So the clock just stops.
the clock stops. When the government lifts the lockdown, the clock resumes. However, and this is a big however, if that suspension drags on for so long that the fundamental commercial purpose of the contract is completely defeated, a party might then have grounds to petition for total termination.
Because it's no longer the same deal.
Right.
Here's where it gets really interesting. 273 is the nuclear option that kills the contract. But we just established that if my costs jump 400% and threaten to bankrupt me, 273 does absolutely nothing to help me because performance is still technically possible.
Correct. You are locked in the vault.
But the civil code doesn't just leave you to bleed out, does it? There has to be a mechanism for the scenario where the vault is still standing, but the pressure inside is building to a catastrophic, lethal level.
There is, and it is one of the most sophisticated, nuanced aspects of the UAE Civil Code, where Article 273 is the nuclear bomb, Article 249 is the judicial scalpel.
Scalpel, I like that.
It is the doctrine of exceptional circumstances, which is commonly known as the hardship doctrine.
Let's dive deep into hardship, because this operates in that murky space just below impossibility. Performance is possible, but it's excruciating.
Precisely. Under Article 249, the steel can still be delivered. The tower can still be built. However, an unforeseen event has occurred that has made the performance of that obligation excessively onerous to the point where it threatens the obligor with grave loss.
Now, I know there are 6 strict criteria for this, and I want to avoid just listing them off like a textbook. Let's test this in reality.
Let's do it.
Let's say my logistics company is contracted to move freight across the country. Suddenly, the local truck drivers union goes on strike, and my labor costs double overnight. I'm losing my shirt. Can I run to a judge and cry hardship under 249?
You can try, but you will fail.
Why? It's unforeseeable and it's ruining me.
Because the first test of Article 249 is that the event must be both exceptional and of a public or general nature.
Public nature.
Yes. A strike localized to your workforce or even your specific sector is considered a private commercial dispute. It is not a general public event. To trigger 249, the event must affect the market or the public at large.
Got it. So give me a comparison.
A localized electrical fire at your specific manufacturing plant is a tragedy. A national grid collapse caused by a cyber attack is a public event.
That distinction is crucial. It stops companies from weaponizing the hardship doctrine to cover up their own operational vulnerability.
Exactly. It prevents moral hazard.
So it has to be a macro-level crisis. But what about the timing? If the national grid collapses, but it collapses the day after I was supposed to deliver the goods, and I was already late,
then you are entirely out of luck. The exceptional event must occur after the contract is formed, but strictly before the obligation was supposed to be completed.
because I was already in default.
Right. If you are in delay, you bear the risk of subsequent exceptional events. Furthermore, we applied the exact same rigorous test of unforeseeability and unavoidability that we used in force majeure.
So the foresight standard is the same.
Identical. If you saw the macro crisis coming when you signed, or if you could have avoided the financial fallout but chose a lazy path, the judge will not save you.
Let's focus on the financial threshold, because excessively onerous and grave loss sound highly subjective. Where is the line between normal commercial pain and statutory hardship?
It's a line that gets debated in arbitration constantly.
Like, if my profit margin shrinks from 15% to 2%, I'm furious, obviously, but is that a grave loss?
It is not. The bedrock principle is that standard commercial risk, normal market fluctuations, and everyday inflation are borne by the parties. That is the nature of business.
You take the rough with the smooth.
Exactly. Grave loss requires a fundamental, violent distortion of the economic balance of the contract. The performance must have become so onerous that it threatens severe financial peril.
So we are talking real damage.
Not just a reduction in profit, but massive, unsustainable, out-of-pocket losses directly attributable to the public exceptional event.
Okay, let's say I hit that incredibly high bar. The state just imposed a massive, unprecedented tariff on my primary material. It's a public event, totally unforeseeable, unavoidable, and it is driving me into a multi-million dirham deficit on this specific contract.
You bleeding out.
Exactly. Under 273, the judge terminates the deal. But under 249, the contract survives. So what does the judge actually do with that scalpel?
This is where the judge exercises profound discretionary authority. The state steps in to override pacta sunt servanda to prevent systemic commercial collapse.
So they rewrite my contract.
In a way, yes. The judge's mandate is to restore economic equilibrium. They will look at the financial modeling of the contract and adjust the oppressive obligation to a, quote, reasonable level.
How does that mechanical adjustment work in practice? Are they just, like, writing me a check?
No, no. They are restructuring the burden between the parties. A judge might increase the contract price, forcing the developer to absorb a portion of that unforeseen tariff.
Okay, so a price bump.
Right. Or they might grant a binding extension of time, relieving you of the massive delay damages accruing against you. Or they might even reduce the quantity of goods you are required to deliver for the exact same price.
So the goal is shared pain.
Exactly. Equitable sharing of the unforeseen loss, rather than letting the entire burden crush the obligor.
I have to play devil's advocate here. From an investor standpoint, this sounds terrifying.
It is a common complaint from foreign investors.
I mean, I signed a fixed price contract specifically to lock in my costs. I want certainty.
Mm-hmm.
And you are telling me that if things get too tough for my contractor, a UAE judge can just open up my contract and force me to pay more. Doesn't that inherently destabilize the market?
It is a profound tension between stability and equity. But the UAE legislature determined that it is worse for the macroeconomy to allow cascading bankruptcies due to public catastrophes than it is to adjust individual contracts.
So saving the market trumps saving the individual deal.
In extreme circumstances, yes. And here is a critical nuance from the jurisprudence that every listener must internalize. The absolute prohibition of contracting out of Article 249.
Wait, really?
Really?
So if I draft a hyper-aggressive contract that says both parties expressly waive their rights to claim exceptional circumstances under Article 249 and contractor absolutely agrees to bear all risks of any and all unforeseen cost escalations, regardless of cause, what happens?
The court will take a red pen, cross out that clause, and ignore it entirely.
Are you serious? Just ignore it?
Completely. Any prior agreement attempting to waive a party's right to invoke hardship under Article 249 is legally null and void. The protection of Article 249 is considered a matter of overriding public policy in the UAE.
That is wild. So it's basically a statutory safety net that you aren't allowed to take down, even if both acrobats sign a piece of paper saying they want to perform without a net?
That is exactly how it functions. The state refuses to let you contract your way into guaranteed ruin via an unforeseen public disaster. You
Right.
cannot waive a public policy protection. However, you cannot use the net if you jumped off the platform on purpose.
Meaning self-induced hardship.
Exactly. If the excessive burden is a result of your own fault or negligence, the door to Article 249 is slammed shut.
Give me a scenario for that.
Say you delayed ordering your raw materials for 6 months because you were trying to play the commodities market and get a cheaper price.
Right.
And then suddenly, a war broke out that spiked the price by 300%. The judge will say the hardship was self-induced by your speculative delay. You created the exposure.
So you acted in bad faith, you lose the safety net.
Precisely.
So what does this all mean for the actual damages? We've talked about terminating the contract under 273, and we've talked about adjusting the price under 249. But when a project grinds to a halt because of a catastrophe, the developer is losing millions in delayed revenue.
Oh, massive consequential losses.
They are going to look for someone to sue. If the meteor hits the site and I can't build, who pays for the fallout?
This is where we introduce the third pillar of our masterclass, Article 287. If 273 is the nuclear option that kills the contract, and 249 is the scalpel that operates on it, Article 287 is the liability shield that protects the parties in the aftermath.
Break down how the shield works, because I'm a bit stuck on the logic here. If 273 terminates the contract entirely, how can a liability shield even exist? Doesn't the shield die with the contract?
That is a highly sophisticated question and a common point of confusion.
Right, because if the contract is voided,
While the primary obligations to perform, like build the tower, deliver the goods, are extinguished, the secondary obligations regarding liability and dispute resolution survive the termination to govern the fallout.
okay, the dispute mechanics survive.
Yes, Article 287 dictates the exemption from liability. It explicitly states that if a person fails to perform their obligation due to a cause beyond their control, such as a natural disaster, sudden unavoidable accident, or force majeure, they are entirely exempt from paying compensation or damages.
So if I prove the meteor strike was a valid force majeure, I don't just get to walk away. I'm completely immune from the developers suing me for their lost profits.
Precisely. The underlying philosophy of civil law is that liability requires fault.
No fault, no foul.
Exactly. If the failure was caused by an external, unavoidable event, you are not at fault. Therefore, it is unjust to make you pay damages for something you could not prevent.
But there's a massive caveat in 287, isn't there? a way that it differs from the hardship doctrine we just talked about.
Yes. And if we connect this to the bigger picture of contract drafting, this is the most critical takeaway for our listeners. Article 287 states that the exemption from liability applies unless there is a specific legal provision or a valid contractual agreement stating otherwise.
So while I cannot contract out of the hardship scalpel in 249, I absolutely can't contract out of the liability shield in 287.
Exactly. You can dictate the financial consequences of a force majeure event.
So how would I draft that?
A meticulously drafted contract might say, in the event of force majeure, the contractor is entitled to an extension of time to avoid delay penalties, but the contractor shall absolutely not be entitled to any financial compensation for extended overheads and must bear all site maintenance costs during the suspension.
So you are contractually shifting the financial burden of the force majeure event back onto the contractor, overriding the default statutory shield.
Yes, you are saying, we agree it's an act of God, but you are still paying for the cleanup, and the UAE courts will uphold that.
That perfectly transitions us into the real meat of this masterclass, the debate. We have the theoretical frameworks. Now let's drag these articles into the mud of real-world Middle East scenarios and see how they actually hold up under pressure.
Let's test the parameters. What is the first scenario?
Okay, scenario A, maritime shipping and geopolitics. We are looking at the Strait of Hormuz.
Always a hot spot.
Exactly. Here are the facts. We have escalating, unprecedented military tensions in the region. In response, the International Transport Workers Federation, the ITF, which is the union representing global seafarers, and the Joint Negotiating Group, the JNG, officially classify the Strait of Hormuz as a high-risk combat zone.
Okay, so an official designation.
Right. Immediately, major global shipping lines suspend all voyages through the strait. This causes cascading delivery delays, and the cost of insurance and rerouting cargo completely around the African continent absolutely skyrockets.
A scenario that is unfortunately highly relevant to current regional practice.
I am the legal counsel for a massive logistics firm. I am contracted to deliver highly sensitive tech components to a server farm in the UAE. The goods are stuck. The client is threatening breach. I need relief. Is this force majeure under 273, or is this hardship under 249?
The analysis hinges entirely on the physical reality of the impediment. Let's look at 273 first. Is performance objectively impossible?
Well, it's really dangerous.
But is it impossible? If the Strait of Hormuz is literally blockaded, meaning military vessels are physically interdicting commercial traffic, and there is absolutely no alternative geographic route to deliver these specific goods, then yes, the obligation physically cannot be performed.
So in that extreme case, it's 273.
The event is external, unavoidable, and unforeseeable, assuming the contract was signed before the escalation. You trigger 273, the contract terminates, and 287 shields you from delay damages.
But wait, that's almost never the reality. The strait isn't physically chained shut. It's just incredibly dangerous, and the insurance premiums have gone up 1,000%. Furthermore, ships can reach the UAE destination by going all the way around the Cape of Good Hope.
Right, the long way.
Yeah, it adds 45 days to the transit time and increases my fuel and operational costs by 400%. But it is physically possible.
And the moment you admit it is physically possible, Article 273 vanishes.
Just like that.
Just like that. You cannot claim force majeure. The UAE courts are incredibly strict on this. Danger and expense do not equal impossibility.
So I have to use the Cape of Good Hope route. But doing so with a 400% cost increase on a fixed-price freight contract will cause my logistics company a catastrophic grave loss. I will lose millions.
Now you pivot to Article 249, the hardship doctrine. You petition the judge, arguing that the military escalation is an exceptional public event.
Which it is.
Yes. You argue that while performance is possible via the Cape, the 400% cost increase makes the obligation excessively onerous, threatening you with grave loss.
How does the judge analyze my 249 claim here? What are they looking for?
They will scrutinize the foreseeability. When did you sign the contract? If you signed it 2 weeks ago, when the ITF warnings were already looming and tensions were high, the court will likely determine you should have foreseen the risk of closure and priced your freight rates accordingly.
So my claim gets denied.
Claim denied. But if you signed a multi-year master service agreement 3 years ago, during a period of relative stability, your argument for unforeseeability is ironclad.
And if I win, the judge uses the scalpel to perhaps force the client to absorb, say, 50% of the Cape of Good Hope rerouting surcharge, keeping me solvent while ensuring the goods eventually arrive.
Exactly. The judge restores the economic balance. They split the baby, so to speak, to keep commerce moving.
Let's move to scenario B, mega construction and infrastructure. Here are the facts. We have a 5 billion dirham large-scale infrastructure project in Abu Dhabi. Suddenly, the region is hit by historically severe weather, a rainfall event that statistical models say happens once in 200 years.
Unprecedented flooding.
The site is totally flooded, underwater. Simultaneously, the extreme weather causes a massive supply chain blackout for essential raw materials coming from Southeast Asia, and local governmental authorities issue new, immediate emergency restrictions on all outdoor labor to manage the crisis.
A perfect storm. You have natural disasters intertwined with sovereign acts.
I am the main contractor. I am bleeding 2 million dirhams a day while the site is shut down. I am also racking up massive delay damages under the contract. How do I leverage these articles? Am I pushing for total termination or just an extension of time?
Well, in mega construction, total termination under 273 is rarely the commercial objective unless the site is, like, permanently swallowed by a sinkhole.
Right. I want to finish the job and get paid.
Exactly. Therefore, you are using the logic of force majeure to seek a temporary suspension of obligations, which practically translates to a binding extension of time, an EOT.
But how does a UAE court interpret foreseeability with weather? It rains every winter. The developer will argue, you're a contractor, you should know it rains, you should have built float into your schedule.
And that's a fair argument for normal rain. The court relies heavily on meteorological data and industry standards. A standard winter storm, even a severe one, is foreseeable. If you didn't allocate float for normal weather, you bear the risk.
But my scenario is a 200-year event.
Right. The once in 200 years event you described crosses the threshold. It is exceptional and unforeseeable by the standard of a prudent contractor.
So I have an exceptional event. I get my EOT for the days the site was flooded. What about the supply chain blackout? My steel from Asia is delayed by a month because of the same storm system?
That requires rigorous causal analysis regarding unavoidability.
Mitigation again.
Yes. Was the blackout truly unavoidable? The developer's counsel will ask, could you have sourced the steel locally in the UAE or from Saudi Arabia?
I could have, but the local suppliers knew there was a shortage, so they jacked their prices up 300%. It would have cost a fortune.
And this is where contractors trap themselves constantly.
How so?
If you could have sourced the materials locally, performance was not impossible. If you simply chose to wait a month for the cheaper Asian steel, the delay was avoidable. You will not get an EOT for that month under force majeure logic.
Because I chose to save money rather than save time.
Exactly. However, if buying the local steel at a 300% premium would have caused you grave loss, you should have procured it to mitigate the delay and simultaneously filed a hardship claim under Article 249 to have the judge adjust the contract price to cover the premium.
That is an incredible strategic nuance. You mitigate to avoid delay, but you use 249 to survive the cost of mitigation.
It's the only way to thread the needle.
And regarding my daily overhead, the idle cranes, the labor camps, who pays for that during the EOT?
We return to Article 287 and your specific contract drafting. The EOT protects you from paying liquidated damages to the developer, but getting the developer to pay you for your extended overheads depends entirely on whether your contract explicitly shifts that financial risk or if it relies on the default shield of 287 where losses lie where they fall.
It always comes back to the drafting. Okay, final scenario, and this one's the bleeding edge. Scenario C-Tech and cyber infrastructure.
Very timely.
The facts. We have a massive 10-year technology service agreement where a multinational firm is managing cloud infrastructure for major financial institutions in the region. There is a sudden, highly sophisticated state-sponsored cyber attack. It completely shuts down digital services and telecommunications, causing catastrophic data delays and financial losses.
This is perhaps the most rapidly evolving area of commercial jurisprudence globally, and the UAE courts are actively wrestling with it right now.
The debate here hinges entirely on the definition of unforeseeability and control. I represent the financial institutions. I am furious. I am bleeding money. I argue to the tech provider. You are a multinational cybersecurity firm. A cyber attack is literally the exact thing you were supposed to foresee and prevent. That is your entire business model.
It's a compelling argument.
Right. You cannot claim force majeure for the very risk we hired you to manage.
This raises an important question. How do we actually define unforeseeable and external in an era where cyber threats are a continuous known reality?
Exactly. If you know there are hackers probing your firewalls every single second of the day, how can a breach ever be unforeseeable?
The judicial analysis here must be intensely technical. The court will not accept a blanket claim from the tech provider that all cyber attacks are force majeure.
They'll dig into the details.
Deeply. The court will order forensic analysis of the specific nature of the attack. Was it a standard ransomware script? Was it a known vulnerability that a routine patch should have caught 3 months ago?
And if it was?
If so, the tech provider was deeply negligent. The event was not external. It was a failure of their internal sphere of control. Force majeure is categorically denied, and they are fully liable for damages.
But what if it was a zero-day exploit? A vulnerability hidden deep in the architecture of the internet that no one in the world, not even the software developers, knew existed until the exact moment a state-sponsored military intelligence unit deployed it.
That changes everything. If the tech provider can definitively prove it was a true zero-day exploit, and they can prove they had implemented industry-leading state-of-the-art defenses that were still overwhelmed by an unprecedented military-grade attack, they have a very strong argument for force majeure under Article 273.
Because it hits all the markers.
Yes. The event was external, being state-sponsored actors. It was unforeseeable, being a zero-day vulnerability. And it was unavoidable despite reasonable efforts because they had state-of-the-art defenses.
And this highlights exactly why technology service agreements must be drafted with absolute microscopic precision regarding the UAE statutory definitions. You can't just write acts of hackers in your force majeure clause and expect it to shield you from your own shoddy cybersecurity practices.
Exactly. The clause must harmonize with the rigorous statutory framework. It must explicitly define the threshold of what constitutes an exceptional, unavoidable cyber event versus standard operational risk that the provider must bear.
This has been an incredibly dense breakdown. Let's synthesize this masterclass for everyone. We started with the sealed vault of Pacta Sunt Servanda. We looked at Article 273, which is the absolute wall, the nuclear option that automatically terminates the contract when performance becomes objectively, physically, or legally impossible.
Right.
We then examined Article 249, the steep hill, the judicial scalpel, that allows a judge to forcibly adjust the financial burden when performance isn't impossible, but an exceptional public event has made it excessively onerous, threatening grave loss.
And we established that both doctrines require an incredibly high burden of proof regarding unforeseeability and unavoidability. Meanwhile, Article 287 provides the statutory liability shield against damages when those events occur, subject, critically, to contrary contractual agreements.
So what does this all mean for you, the listener? Whether you are drafting a tech agreement, negotiating a maritime logistics deal, or managing a mega construction contract, the direct application is this. A well-structured commercial contract doesn't just copy-paste boilerplate common law clauses.
It absolutely cannot.
It must meticulously define force majeure events, notification procedures, and financial risk allocation to harmonize seamlessly with these strict UAE statutory frameworks. If you don't understand how your drafted clauses interact with Articles 249, 273, and 287, you are leaving your vault completely exposed to the earthquake.
Very well said. The statutory framework is the ultimate safety net, but you must weave your specific contractual clauses into it effectively, knowing exactly which protections you can modify and which, like 249, are absolute public policy.
As we wrap up this deep dive, I want to leave you with a forward-looking puzzle. Something that wasn't explicitly answered today, but is coming at us incredibly fast.
Oh, this should be good.
As we approach the June 2026 enactment of the new Civil Transactions Law, consider this. We're entering an era of absolute AI-driven predictive modeling. If artificial intelligence and quantum computing can soon accurately predict geopolitical conflicts, severe weather patterns, and macroeconomic supply chain collapses months or even years in advance, does the legal standard of unforeseeability completely disappear? Right. If an AI could have seen the earthquake coming, will UAE courts rule that you should have seen it too? In a world where data makes everything predictable, does the doctrine of force majeure effectively cease to exist?
That is a profoundly chilling thought for risk managers and legal draftsmen everywhere. It fundamentally threatens the entire architecture of commercial risk allocation.
Something to mull over as you review the risk profile of your next multi-billion dirham contract. Thank you for joining us for this advanced CPD Masterclass deep dive. We will see you next time.